In this video, I'm going to explain how to obtain power of attorney in New York. I'll guide you through step by step on how to obtain power of attorney in New York, as well as explain the different types of power of attorneys available. So by the end of this video, you're going to have enough information to create your very own power of attorney. And by the way, if you would like to get help creating power of attorney, I suggest you contact people from lawdepot.com. They are professionals and they will be able to help you. I'm going to leave a link for their website down in the description of this video. And with that in mind, let's jump right into it. Understanding power of attorney. What is power of attorney? A power of attorney, often abbreviated as POA, is a legal document that empowers another person known as your agent to make important decisions on your behalf. You, as the creator of the POA, are referred to as the principal. In New York, as well as in every other state, you don't need to hire an attorney to create a power of attorney. You can draft it yourself, saving both time and money. As long as you adhere to New York's legal requirements, a self-created POA is just as valid as one prepared by a lawyer. Types of power of attorney in New York. New York recognizes several types of powers of attorney, each with a specific purpose and distinct powers granted to your agents. First, durable power of attorney. When a power of attorney is considered durable, it means that your agent's authority continues even if you become incapacitated, such as being in a coma. Durable POAs are often used in estate planning because they prepare for situations where you may be unable to communicate important decisions on your own. In New York, all POAs are durable by default unless you specifically state otherwise in your POA document. Even so, it's advisable to include a statement in your POA explicitly indicating that you want it to be durable. Statutory power of attorney, financial power of attorney. In New York, you can create a statutory power of attorney to grant your agent authority over your financial and business matters. This includes tasks such as paying bills, filing taxes, selling real estate, and more. This type of POA is commonly referred to as a financial power of attorney. It's important to note that a statutory power of attorney does not grant your agent the authority to make healthcare decisions on your behalf. Those are covered by a healthcare proxy in New York. As of June 13, 2021, New York revised its statutory short-form power of attorney to make it more user-friendly and accommodating. Some notable changes include relaxation of exact wording requirements. Previously, New Yorkers had to use the exact wording provided in the statute when creating a statutory short-form POA. Deviations from the prescribed language could lead to rejection. Now, the rules are more flexible, and while a statutory POA should closely follow the statutory language, minor deviations are accepted. Defined authority for healthcare cost decisions. The new law provides clearer guidelines on the extent of power your agent can have over your healthcare-related financial decisions. Your agent is considered a personal representative for healthcare cost decisions, allowing them to access healthcare billing records to verify accuracy. Increased gift allowances. Under the new law, your agent can make gifts of up to $5,000 annually to support your family and personal needs without the need for an additional form. If your family's financial needs exceeds $5,000 a year, you can authorize your agent to provide more financial support by specifying this in your POA. Third, healthcare proxy. A healthcare proxy allows you to designate a healthcare agent who will have the authority to make healthcare decisions on your behalf if you are unable to make them yourself. These decisions may involve treatment options, medication, surgery, end-of-life care, and more. A healthcare proxy is also referred to as a medical power of attorney or healthcare power of attorney. In New York, this document needs to be signed by you and 2 witnesses, and it doesn't require notarization. New York provides a healthcare proxy form on the New York State Department of Health's website. You can use online software such as lawdepot.com to create a customized healthcare proxy in line with your preferences. New York power of attorney requirements. Before creating a power of attorney in New York, you must meet specific requirements. First, age. You must be at least 18 years old to create a power of attorney. Second, mental capacity. You must possess the mental capacity to understand the nature and consequences of creating a power of attorney. Legible font. If you're typing your POA, use a font size that is at least 12 point and is legible. 4. Signing and notarization. Sign and date your POA in the presence of 2 witnesses and have it notarized. In New York, a notary can also serve as one of the witnesses. However, if you're creating a healthcare proxy, you only need witness signatures, not notarization. Number 5. Agent's signature. Your chosen agent must also sign and date your POA. For a New York statutory form of attorney, their signatures should be notarized. It's not necessary for your agent to sign the POA at the same time you do, but their signature must be obtained before they can act as your agents. Number 6. avoiding conflicts of interest. A beneficiary of your estate should not serve as a witness for your POA to avoid any conflicts of interest. This includes your spouse, children, or anyone named in your last will and testament. Additionally, your agent cannot serve as a witness, although they are still required to sign your POA to accept their authority. Once your power of attorney is created, it's advisable to provide a copy to your agent and inform them to your expectations. Your agent may need to present the POA to relevant authorities such as banks or hospitals to prove their authority to make decisions on your behalf. Who can serve as your agent in New York? According to New York law, your POA agent can be anyone who is at least 18 years old and possesses mental capacity. It is not necessary for your agent to be a lawyer, and in most cases, individuals do not choose lawyers as their agents. Your agent could be a family member, close friend, business partner, or anyone you trust to act in your best interests. By law, your agent is obligated to follow the instructions outlined in your POA, act in your best interest, keep your properties separate from their own, disclose their relationship as your agent whenever they sign on your behalf, and maintain receipts for all payments and transactions made on your behalf. Do you still need a will if you have power of attorney? Yes, it is generally recommended by estate planning professionals to have both a will and a power of attorney. These two documents serve different purposes. Power of attorney. A POA is utilized during your lifetime and allows your agent to make important decisions on your behalf if you become ill or injured. It covers medical and financial matters but does not address the distribution of your assets after your passing. Last will and testament. A will comes into effect after your death and outlines how you want your property and assets to be distributed to your heirs or beneficiaries. It allows you to specify who receives your assets, personal belongings, and even guardianship for minor children. In summary, while a power of attorney is crucial for handling affairs during your lifetime, a will is essential for ensuring that your assets are distributed according to your wishes after your passing. How to make a New York power of attorney. Here are the basic steps to create your New York power of attorney. Number 1, determine the type of POA. Decide which type of power of attorney you need based on your specific circumstances. For estate planning purposes, consider a statutory power of attorney for financial matters and a healthcare proxy for healthcare preferences. Number 2, select your agent. Speak with the person you want to designate as your agent and ensure they're willing to serve in this role. Your chosen agent must also sign the POA document to accept the responsibilities. Number 3, define agent's authority. Clearly specify the powers and authority you want to grant to your agent. Describe the financial or medical decisions you want them to manage on your behalf. Number 4, obtain a power of attorney form. New York provides residents with both a statutory short form power of attorney and a healthcare proxy form available for free. Alternatively, you can use self-help estate planning platforms like lawdepot.com to create a durable power of attorney or a living will, which includes a healthcare proxy tailored to your preferences. Number 5, complete, sign, witness, and notarize. Fill out the chosen form, sign it, and have it witnessed by 2 individuals while notarizing if required. Remember, for a New York statutory power of attorney, your agent's signature must also be notarized. Your witnesses could not be your agents or anyone who stands to inherit from your estate. Number 6, inform your agent and interested parties. Share a copy of your POA with your agent and any other relevant parties such as your bank and medical office. Number 7, secure your POA. Keep your power of attorney documents in a safe place alongside your other estate planning documents. Number 8, regular updates. Remember to update your POA as your circumstances change. It's generally recommended to review your documents every 3 to 5 years or whenever a significant life event occurs. By following these steps, you can ensure that your power of attorney is legally valid and reflects your intentions accurately. And don't forget that if you would like to get help creating power of attorney in New York, I suggest you contact people from lawdepot.com. They are professionals and they will be able to help you. I'm going to leave a link to their website down in the description of this video. I hope this video was helpful. Thank you so much for watching. Subscribe.